May it please the court, Madam Court Reporter, Madam Balloff, Mr. Schroyer, Mr. Merkel, Caitlin, Jason, and Stephen Nolder. Good morning, ladies and gentlemen of the jury. In the beginning of this case, you said you took an oath, and you stood up and you swore not to form any opinions, conclusions, until you heard all the evidence, the closing arguments, and the instructions of law. We've been a little busy, but we've tried to watch you. And I believe you've kept that duty and met the oath. And for that, I thank you. I thank you because without you doing that, we wouldn't have the best criminal justice system in the world. Without your civic duty, we wouldn't have the best system. So from all of us, we thank you for your service. December 4th, 2020, ladies and gentlemen, was a tragic day. The Goodson family lost a son, a grandson, a brother, a nephew, a cousin. Their family will be affected for the rest of their lives from their loss. December 4th, 2020 affects all of us in this courtroom. Each of us will take a piece of that with us for the rest of our life. It's an example of an action and a reaction affecting so many people. But your role here, ladies and gentlemen, as a juror, goes far beyond your sincere belief of the empathy for this situation. When you step back to that jury room, ladies and gentlemen, the call of justice and your legal duty requires you to set aside the understandable sympathy and empathy that you have as human beings for the loss in this situation. But that's why you have to follow the law and the judge's instructions and keep your oath. December 4th, 2020, not the defendant, but Jason Meade. He has a name. Jason Meade was doing his job. Jason Meade, it's a simple case, ladies and gentlemen, it really is. Jason Meade was doing his job the way he was trained to do. He was investigating someone, a male, who pointed a gun at him and was waving a gun. Casey Goodson, for whatever reason, just like Ms. Stevens told you in opening, for whatever reason, turned with that gun towards him. And Jason Meade defended himself based on his training and protected himself. The government, through hindsight, and the government, through selective misrepresentation, puts all these other facts there. The basic concept of the facts were he was investigating what he saw, and he was placed in a life or death situation by the actions of Mr. Goodson. With those facts and the jury instructions that you have, your verdict will be, even though it's hard, that you must acquit Jason Meade of these actions. Now, there's a basic analysis in the framework of those jury instructions. We talk about it in voir dire. They have a burden of proof beyond a reasonable doubt, proof of such nature you rely upon it in the most important of your own affairs, a surgery for a child, care for an elderly parent, one of the most important decisions in your life, a first, a second, a third opinion, ladies and gentlemen. That's the type of proof beyond a reasonable doubt. And that burden never shifts. It stays with them the entire time, ladies and gentlemen. It never shifts. If for some reason you believe they met their burden, then we welcome the burden shifting to us of proof beyond a preponderance, more likely than not, a feather touching a scale. Yes, I think that's the case. Yes, I think so. And our burden, more likely than not, actually trumps the higher burden. Doesn't make a lot of sense, but that's the way our legislature does it. If they don't meet their burden, it's not guilty. And even if they do meet their burden, and we do, it's not guilty. Now, closing arguments. It's a time to bring up some inferences, apply them to facts, point things out to you. And there's three common themes in the government's case. Three common things that run through the entire thing. Lack of context, low quality of evidence, and misrepresentation. All three And when you look at those, you can call them each different thing, but what they amount to, each and every example, and there's many, but I'm only going to focus on a few. Each and every example is a building block of reasonable doubt. Each and every example in and of itself is enough to prove that they didn't meet their burden, because it's a building block of reasonable doubt, and it will get higher and higher, ladies and gentlemen. First one, they don't give you anything in context. They take everything and take it out of context. And what I mean by that, ladies and gentlemen, is then we have to put it into context for you. Because in order to make an informed choice here, you need the full picture. You need the entire context of the situation. This case is about context. The government doesn't want to provide it. They openly resist the opportunity when it's apparently appropriate to do. We have to provide the contrast. Example, you just saw it in closing. They started their case in opening. The first thing Mr. Merkel said was 6 shots in the back. The first thing Mr. Merkel said in his closing was 6 shots in the back. That's all they have, ladies and gentlemen, okay? But that's all, that's where they stop. Because someone got shot in the back, therefore it must not be justified, okay? Now, they don't even start from the interaction. The law will tell you that you have to start at the initial interaction of your analysis where Mr. Goodson and Jason Meade's paths crossed, where they became intersected, at that intersection. They start at the end. That's all they have. They just showed the video. Think about what it confirmed. The car position, Jason's first position. What happened? He saw what he saw and he did a U-turn. All of that was confirmed in the video. He pulled over at Estates. That was confirmed by Rosser. The full picture, ladies and gentlemen. And it's amazing what the government does. Mr. Merkel is an attorney. You heard from Dr. Shepler, an expert on wound paths and trajectories. And she told you, with a person with 6 shots in the back, right to left, upward, and back to front, can be consistent with someone turning this way. That's because the projectiles are
overruled the closing arguments.
It's exactly the testimony. It's not that complicated. You can still have 6 shots in the back and not be facing directly across from them. You can still have 6 shots from the back and be turned this way because it comes from over there. Right to left, upward, and back to front. Somehow, Mr. Merkel, now, Doctor, we asked the coroner, can you tell the order? Absolutely not. We asked Dr. Bauer, can you tell the order of the shots? Absolutely not. Dr. DeMulen, can you tell the order? Absolutely not. 2 of them are their experts. And Mr. Merkel just got up here and told you, don't listen to their evidence with the experts. Listen to me, because I believe these happened at this time, because that's why the body's bent over here like that. Again, they add their own context. It's disingenuous. What did Dr. Shepler say? I can't tell you in any way, shape, or form how the body was positioned. And if anybody does, they're giving you crap. Again, a building block of reasonable doubt, ladies and gentlemen. No matter what, Mr. Merkel claims to be now a coroner and a biomechanic expert. Example 2, they hit this one. They hit this one in their closing. The Seth Penny video. They can't help themselves, ladies and gentlemen. Where did they start that in the case in chief? At the 38-second mark. They don't even include the part with the question. They don't, because they don't care what the question was. They don't want to give it context. They only want the answer, because that answer fits their narrative. They started from a premise of 6 shots in the back and worked backwards. And that's when it doesn't make sense, ladies and gentlemen. Who provided you context to that? Geez, we did in our questions of, Mr. Nolder did in our questions of Officer Rippey. Hey, I'm going to play you the full video. Do you hear the question that was asked? Yes. How'd I miss the call? Okay, what did you observe next? He's trying to answer. He's keeping people off of the street. He's telling hey, is the scene clear for the medics? All the different things, comes back and says, it was the U.S. Marshals channel. They leave that out just now. It was on the U.S. Marshal channel. That's how you missed the call. Was the question, why did you fire? No. Was the question, tell me why you pulled the trigger? No. The question that was answered, he was trying to answer to was, how'd I miss the call? And somehow they distort that.
Objection, Your Honor.
Overruled, closing arguments.
Somehow they have to distort it because it doesn't fit their narrative of 6 shots in the back, of what was happening. Geez, Jason Meade is supposed to say to anyone who comes up there, hey, this is why I pulled the trigger. You heard plenty of testimony from officers. They're trained not to do that. They don't ask the person. You heard from Inspector Youngless, pretty impressive guy. 2 things, are you okay? And did you fire? Yes. Answer the questions. Hey, how did I miss the call? He answered the question. They don't even have the courtesy to give you the question that was asked. We had to. Example 3, Dr. Bauer. This is the epitome of giving you evidence without context. They actually had Dr. Bauer testify about 5 slides that Dr. DeMullen talked about. How on earth can you testify about something if you weren't in the courtroom listening? How can you try to give an opinion? The audacity of Dr. Bauer to say, well, I have a picture, this must be what he meant. Mr. Noldo asked him, Dr. Bauer, did you listen to his testimony? No. Again, they take out of context of 5 pictures, and they have someone comment who has no idea. How many times did Mr. Schroyer ask Dr. DeMullen over and over again, hey, on this picture number 4, were you trying to show this? No. Hey, on this picture over here, were you trying to show that? No, you're mistaken. Hey, what were you using this slide to do this? Why did he put a foot in the air? Because in Jason Meade's statement, he said, I saw him stepping up to the threshold. He's just trying to test the hypothesis. Could he have been in this threshold? And even though Mr. Merkel misstated it, he said it's more likely that he was. He had it, he tied it to the 3 bullets, he did the anchoring, and he said, yes, it's more likely that he was in the threshold. That's the hypothesis. More likely, based on a reasonable degree of biomechanical certainty. Example 4, Detective Hughes. By January 2021, Jason Meade had given his words, given his statement of his perceptions and his beliefs and his fears that occurred on December 4th. A month later, without seeing a video, without knowing what witnesses said, without knowing any of that stuff, based on his memory, okay? His observations. Jason didn't have to give that statement. And what did we talk to Detective Hughes about? Detective Hughes, you'll have the email back there, was invited. If you have any questions, please ask us from the lawyer. If you want to talk to Jason, please let us know. If you have any concerns, all of a sudden, Detective Hughes has concerns, right? Did Detective Hughes do anything when he got that statement if he had these concerns? No. Days became months, months became years, and 5.5 years later, even though prior testimony at a hearing, he had the opportunity under oath to talk about his concerns. There's never a written report. There's never a document of any of that concerns, but he had concerns. 5.5 years later, because it doesn't fit in their narrative now, that's why he has to have concerns. Again, part of the context. You don't get many chances. A good detective reads the stuff, compares, they say, geez, I got some questions, I got some issues. Gee, I wonder if I've been asked can I talk to you? It was an open invite, ladies and gentlemen. Full context is following up. And it's especially the case here because he testified on oath before and he never said a word. The first time ever to people was to you. That's what happens when you start from a premise of 6 shots in the back, and that's all you have. Another example of the government putting stuff out of context. And again, all of these are individual building blocks of reasonable doubt, and that's their burden. beyond it. Dr. Bauer's need to place Casey Goodson into the kitchen to make his math work, okay? What do we know, ladies and gentlemen? What do we know? He likes angles and he likes measurements. They show a picture to him from the Rippy video that shows Mr. Goodson's feet there at the end of the doorway. Mr. Nolder said, hey, Dr. Bauer, did you do that analysis? Did you do the measurements? No. You could have, right? He chose not to, right? He could have, all right? And he even said, Dr. Bauer said, well, the momentum probably moved him to there from the fall, which actually placed him closer to the threshold. And Dr. Bauer said, I've reviewed all these things and all these objective materials. Yes, I consider those. Hundreds of documents. And the reason we asked him about it's the first time he's ever testified in a criminal trial is because in a criminal trial, in the justice system, you hear 911 calls. And you heard a 911 call. Remember what he said to Mr. Nolder? I don't remember if I heard that or not. I don't remember if I heard that or not. Ladies and gentlemen, that 911 call is haunting. You won't forget it. And he's an expert, but you know why he has to disregard it and not give you the full context? You know why, ladies and gentlemen? Ms. Stevens?
At my house. He lives here with me.
So who shot him?
I don't know. I just
Okay.
heard the gunshots and I would get up and he's laying in the door.
Okay.
He's laying in the door. This is the first civilian. And the first observation she has, remember, she hears the chandelier clashing. She runs out there past Ernest and she looks around. And unfortunately, she was there that day. And unfortunately, she has to see her grandson laying face down at the time with his arms like that. And as soon as she picks up the phone to call 911, what does she say? He was laying in the door. Not in the kitchen, not in the doorway, in the door. How else does she corroborate that? She was their very first witness. May I have the Elmo? This is where she puts him, in the door. That's her writing that Mr. Merkel had on that. In the door, in the threshold. But that doesn't fit Dr. Bauer's narrative and his math and his model and his surrogate. So that's why he doesn't consider it. That's why he didn't remember the 911 call. When you have your first witness on the scene say in the door, why else, ladies and gentlemen? She didn't need a surrogate to convey what she saw. She didn't need to be paid a king's ransom like Dr. Bauer to try to say what he saw. Unfortunately, she was there. But who corroborates what she said? You're going to have Exhibit 27 back there, Jason Meade's words and observations and beliefs and fears. And in that, he says, I couldn't close the door. The body was there. I couldn't, the door wouldn't close.
Objection.
Overruled. Closing arguments.
It's in the statement that the door couldn't close. He then pulls him and rolls him over. The door couldn't close because he's in the threshold because his feet are there, ladies and gentlemen. And he's pulled over from the front to the back, ladies and gentlemen. Dr. Bauer doesn't even know that. He just has got him laying in the back and his momentum took him there. He doesn't even read the reporter, Jason Meade's statement that he rolled him over. Who else corroborates that besides Sharon Payne and Jason Meade? Jenny Jones, again, comes running out, not sure, looks over, she can only see Casey's hands like this in his eyes, cannot see anything below the chest area because it's out in the doorway, it's in the door, it's in the threshold. Now, let's use your common sense, ladies and gentlemen. Common sense, right? Where was most of the glass found from the storm door? On the step on the porch. You'll have many pictures of it back there, okay? So if the door is closed, ladies and gentlemen, all right, and the glass goes, the projectiles come this way, the glass is going to be inside the door, inside the kitchen. If the door is open, ladies and gentlemen, if it's pulled to be open and it's resting on somebody, okay, like Jason Meade said, read his statement, was resting against the door. The door was resting against it. And the projectiles come through here. Where's the glass going to be? Using your common sense. On the stoop. On the stoop. That's collaboration using your common sense, not a 3D model. That's just basic, ladies and gentlemen. But they don't want to give that to you. They only give you part of the concept. Again, another building block of reasonable doubt. Partial content, the junk science by Dr. Bauer. Again, partial, out of it, angles and measurements. At a prior hearing, he was asked, can you give us the amount of feet that your model puts Casey Goodson into the kitchen? That's the issue, whether he's into the kitchen or on the threshold. Yeah, I'll get it for you. Does he give it? No. Can you give us the angle that you put the door being open or closed? Yeah, I'll get it to you, under oath. Does he do it? No. To you, he says, oh, I sent the whole thing to you guys. At any time did Dr. Bauer turn to you and said, this is how many feet I placed Casey Goodson in the kitchen in my model? No. At any time did he say, this is where I had the angle of the screen door? No. And they would even ask him. It's cross-examination. Mr. Norris was like, hey, you never gave me that information. It's a wordplay and stuff like that. All he had to do is turn to you and say, this is how many feet I had the model into the kitchen. He can't, because that blows up his whole theory, ladies and gentlemen. He can't. We provided the full context. Remember, keep this in mind, Dr. Bauer has everything flat. Everything flat, even though everyone who testified about trajectory, when it goes to an intermediate object, okay, it can wobble, it can change direction, it can fall, they call it tumble, and it can fragment. You heard a lot about fragmenting, right? Not to Dr. Bauer. It's got to be straight, because it's got to fit his science. Even Professor Stoughton's direct testimony, where did he start it at? DeSales Estates. That's the first question they asked him about on December 4th actions. He doesn't start up at the intersection, even though he told you correctly that your analysis is confined to from the time at the intersection where they had interaction until the time that the use of force is done. Nothing before, nothing after. He agreed to that. He confirmed the totality of it. Again, we had to bring out the intersection with him. And what did he say? At the end of his testimony yesterday, on the cross, he said, well, yeah, obviously he reacted to something. That's why he did the U-turn. No, but they think, they got to tell you he made it up. They got to tell you that he's lying about seeing the gun at the intersection. Again, another building block of reasonable doubt. Quality of the state's evidence. Call it what you want, quality. Let's talk about this. I was wrong in voir dire. I didn't think anyone would lie. You witnessed a pure example of lying put on by these two people. They put,
Overruled. Closing arguments.
the government called Chris Korn to the stand. All right, let's look at this. The government called Chris Korn to the stand after he's already watched prior testimony at a hearing, right? And let's look at what he told you. Well, I saw someone dancing, raising his arm, maybe singing, but I didn't see a gun. They have to have that narrative out there that he didn't see a gun, because then maybe you won't think that Jason saw a gun, a trained officer in spot number 1. They have to do that. Ladies and gentlemen, it's so easy. When you look at that video that Mr. Merkel-Schroy just showed, that van is still moving as Casey Goodson comes by him. I submit to you that when you're driving and you're going forward and you're stopping, you're looking where you're stopping. This guy wanted some fame from the prior testimony, okay? You're looking forward. And then what did he describe? He described an afro. We know that's not the case because we know there's a skull cap and a hoodie. Oh, no, wait, not an afro, a ponytail. You can't see a ponytail if the hoodie's up. I thought it was a female at first. He actually said that. Still moving forward. The worst part, ladies and gentlemen, the biggest hypocrisy of this case about lying. Physical evidence doesn't lie. The glass on the door doesn't lie. Chris Korn lies, and he got caught in 2 of them. The first one, ladies and gentlemen, he deletes his evidence before his FBI interview. Doesn't tell them, okay? He deletes it. Geez, now we got to come up with a reason why he deleted it, okay? Mr. Nolder asked him, hey, did you have any contact with the Goodson family? Tanala Payne. Nope. Mr. Bowman said, well, the prior hearing, you said you contacted them 4 or 5 times. Not sure. Are you kidding me? Let's take it one step further. Mr. Schroeder, not once but twice, asked Mr. Korn, why did you delete your social media before talking to the FBI? You know what he said? I was getting so many friend requests. Too many friend requests. Okay, all right. That's okay to me until you get to the evidence, ladies and gentlemen. Until you get to the evidence. Perjury is making a statement knowing it's false under oath. Another type of perjury is making 2 statements under oath that aren't consistent, okay? He did both. One, when he said, oh, no, I've never contacted him. Oh, at a prior hearing, he said I contacted him 4 or 5 times. But then we're back to, why'd you delete your social media? Too many friend requests. The government's expert, Detective Howe, provided 4 reports. Did the government talk about report number 4? Hell no. Ms. Stevens brought it out. And it's pretty simple, ladies and gentlemen, because Detective Howe does a report, sends it to them, and then they send it to us. So either they didn't read the report or they didn't care and asked him that question. Because when Ms. Stevens asked Detective Howe, hey, did you do analysis that shows whether or not he had any friend requests prior to him deleting the information, right? You remember that? The answer was, yeah, I did the analysis. Were there any friend requests? No. That's their evidence. That's their expert who says there is that he received no friend requests during that time period. And ladies and gentlemen, they knew that, but they still put up a liar and asked the liar that question. That's a building block of reasonable doubt. That's low quality evidence. I don't know if it's incompetence. I don't know what it is. But when you have information that says there is no evidence of a friend request, and they give it to us, and we see it, and we ask their expert that question, they already know the answer to. That's how desperate they are in this case, because all they have is 6 shots in the back. Second one, the quality of evidence, the AirPods. Mr. Merkel didn't get a chance to talk about it. The AirPods, let's talk about it. All this stuff about what was playing on the phone, right? And things like that. Why do they do that? Of course Jason Meade didn't know he had AirPods. He had a skull cap on there, right? And of course you're not supposed to consider that, okay? Because he didn't know it, so you don't consider that. But they have to do that. And then in that situation, ladies and gentlemen, they want you to believe that what was playing on the phone was coming through the AirPods. It's in report number 4 again. They gave it to us. And Ms. Stevens very effectively said, Detective Howe, is there any data that you saw confirming that what was playing on the phone came through the AirPods? I cannot, it did not. There is no data. Within a reasonable degree of scientific certainty, there is no data. But yet they still put forth that evidence to try to get you to think, why would he do this? Why would he do that? AirPods, he must not have heard them. Again, and it's disingenuous because their own evidence that they gave to us shows that there's no data. You can see if it happens or not. There was no data showing that it was playing in the AirPods. That's their case. Next one, Detective Hughes. Penny's body-worn camera. I asked Detective Hughes, you were concerned with what he said at the porch? He goes, yeah. Did you go interview Officer Phillips? That's who asked the question. No. Well, why would I? Wouldn't you want to have the person interview who asked the question? Hey, Officer Phillips, why'd you ask the question? What question did you ask? And were you okay with the answer? And Detective Phillips, did you ask why he shot? They use word games. How'd I miss the call? What happened? What happened? Oh, how'd I miss the call? Gee, he gave the answer, ladies and gentlemen, and it's factually correct. Detective Hughes, this is a good one. The Extended Magazine. The Extended Magazine. Their gun expert, Caleb Worley, expert in guns and rifles, said it's an extended magazine. Every single police officer they put on said it's an extended magazine. Everyone who Detective Hughes has admiration for and holds them in high regards said it's an extended magazine. But it doesn't fit their narrative because maybe if they say it's not an extended magazine, then if he's pointing and waving like that, Jason Meade couldn't have seen it. He's on an island. Detective Hughes is the only person from law enforcement who says, oh, I don't consider that an extended mag. Nice try. Nice try. Put yourself on an island against the people. Again, why? Let's get just right to it then. just made an argument about a flimsy holster. Who's the person they asked about a flimsy holster to? The reason they had to ask Detective Hughes about the flimsy holster is because Detective Kroom said, I'd say, same holster I've used. I've run 100 times with it and it's never falling out. I've chased suspects, it's never falling out. Detective Kroom has it. They didn't like that answer because it doesn't fit their narrative. So what happens? They put Detective Hughes up there and says, hey, that's flimsy, right? And I'm like, well, geez, have you ever used it? No. Are you kidding me? They put a witness on the stand and asked him about the flimsiness of the holster. And Mr. Merkel just argued it. And they did it with a detective that's never had it, never used it. That's desperation, ladies and gentlemen, to fit the narrative. Let's talk, and again, those are all building blocks of reasonable doubt, ladies and gentlemen. Let's talk about misdirection. And he did it. They can't help themselves. The last question he asked, they did it. They try to play on your emotions. You know, and you have the instructions, you know that the instructions will direct you to start the analysis at the time Jason Meade and Mr. Goodson first encountered one another at the intersection up until the time he discharges a service weapon. That makes common sense. You can't, if the officer didn't know something, you can't take it in the equation, okay? So, but why do they put all these things in? Because they want to play on your emotions. They're hoping you're inquisitive. And when I objected, he asked the question, why? That's what they want. They want you not to look at that time frame and apply the law of facts, but why? Why would Casey Goodson do something if he had the safety on? Nobody knows if the safety's on. It doesn't come into the equation. They know that. But yet that's what they're trying to do for proof beyond a reasonable doubt. That's what they're trying to do, ladies and gentlemen. You can't consider of it. Their own expert, Professor Stoughton, said, no, you can't consider, you can't, in your analysis is not to consider anything that the officer didn't know. The dental receipt, the AirPods, the subway receipt, the way Mr. Goodson parked the car because across from the fire hydrant, that's how the family parked the car. The front door not being used because it sticks. They use the side door. The dog's names, the floor plan. Safety on the gun. They can't help themselves. Their own expert told you you're not allowed to use that in your analysis. They just keep going. They just keep going. The CCW permit. Jeez, he has a CCW permit. Why would someone with a CCW permit be reckless and dangerous with a gun? A CCW, why? Okay, that's what they want you to think. But Jason Meade had no idea about it, so it doesn't come into your equation. But what do you know about it? You know that after he got the CCW permit, he had an accidental discharge in the kitchen with his grandmother and uncle there. He knows the grandmother testified he always takes his gun with him in the car all the time, and he doesn't put it up. And you know from the picture that Ms. Stevens showed in the post out there that he points the gun in the car. Misdirection, again, a building block of reasonable doubt. The holster we've covered, the CCW permit we covered. Okay, again, the so-called reenactment by FBI Agent White. All right? Hey, I'm trying to do the concept. Just be fair about it. Just give the full picture, right? What do? All right? Where do they position the truck? They have no idea. They position it somewhere. Okay, we'll position it at that place, then move it 2 feet up, then move it 3 feet up, and do the same thing, right? Or move it back. But don't just do it from one spot because they can't say, they have to guesstimate where it is. No northbound traffic? They don't have any northbound traffic in their example. No matter what Mr. Merkel says, you see a northbound car clear the intersection before Mr. Goodson turns. It's there. You'll see it back there. They don't put that in there. And they put a mask on the person in the car. Jason Meade said he thought he was shouting, the person in the car. Chris Korn said he thought he was singing, but they put a mask on the person in the car. And ladies and gentlemen, it's coming from a camera. And you heard testimony that a camera doesn't catch what the human eye does. A human eye, when you look at something and you focus, you can focus in. A camera, you can't. It catches pixels. And you heard about the fisheye with the body-worn camera. You can't look. When you see something, ladies and gentlemen, if you see something in someone's hand, you zoom in on that. That's what the human eye does. The photograph that they use, remember that photograph from the street, right? At the end of the street, looking back down towards the car that Agent White talked about? Okay, In Jason Meade's statement, you will read, I pulled over near Sales and Estates, several houses north of the car, okay? The FBI agent used 7, okay? Did they put someone who's 6'2" standing outside the car in the picture? No. Did they do it from 7 houses? 1 means 1, a couple, or 2 means a couple, several is 3, 4, 5, 6, etc. Again, take the picture from 6, take the picture from 5 houses, take the picture from 4 houses, take the picture from 3 houses, give it context, give the full picture. They pick and choose what they want. They chose 380 feet away. That's not what Jason Meade said in his words. He said, I was several houses north. How do you navigate this misdirection? Ladies and gentlemen, you do it with common sense and you compare the physical evidence. Mr. Merkel talked about the physical evidence to the law. That's what you do. Example of common sense. You saw it. You heard Inspector Youngless talk about OODA. OODA, observe, orient, decide, and act, right? We had a perfect example of that. Mr. Scanlon talked about that as well. A perfect example. May I have the screen?
Each exhibit.
I'm sorry.
Sorry.
Your Honor, objection.
Each exhibit.
Sorry.
Sorry.
Now pay attention. Watch Detective Williams observe the recklessness of Mr. Merkel.
Each exhibit.
He orientated.
Sorry.
He decided, he acted. Okay, one more time, Ms. Stevens. The only recklessness in this trial was his handling of the left. Watch it. He's looking. Oh, he points it at him.
Each exhibit.
Gets away.
Sorry.
And Detective Williams knows that gun's not loaded. Detective Williams knows that gun can't be fired. But what you saw was, I observed something, I orientated myself to it, I decided what to do, and I acted. That's how they're trained, ladies and gentlemen. That's how law enforcement officers are trained. You heard Mr. Scanlon say, I can't stop the OODA, even in retirement. That's how important it is when a gun gets pointed at you, one in a safe setting with no ammunition. That's how an officer reacts. The glass on the boards, we talked, the holster, common sense. There's gun, there's blood and DNA on the gun, DNA on the trigger to one person. Is there any blood or anything on the holster? No. And on the clothing, it's underwear, it's pants, it's a shirt, it's a sweatshirt, all over it. They want you to think, oh, somehow this flimsy thing, Casey never had the gun in his hand, it flipped out somehow. But it didn't get any blood or anything on the holster. Misdirection, the corner. Dr. Bauer in the corner. Dr. Bauer, 7 times I counted, said the trajectory was fairly flat. Flat, fairly flat, flat. Ladies and gentlemen, when you have that coroner's report back there, not one time will Dr. Shepler identify the path of the trajectory of the wounds as fairly flat or anything like that. They're all upward, some more significant than the others. But that's how Dr. Bauer has to couch it because he has to have that. He has to have the flat stuff. Minor injuries. Look at the coroner's report. You'll see minor injuries on the left hand, left forearm, the left back, down in there, part of the right thing up here, okay? Minor injuries, ladies and gentlemen. That's from the glass. So that's how you know that the door was on there, ladies and gentlemen. And where you won't find any, ladies and gentlemen, is on the right hand, the hand that had the gun. You won't find any in the coroner's report. Why, ladies and gentlemen? Because if the door is resting back here, okay, and I'm pointing back there, then my hand's out like that, ladies and gentlemen. I've turned, I'm on the threshold, I'm standing on the threshold, and the glass hits all of this area, ladies and gentlemen. And unlike what Dr. Bauer said, I don't have to turn my shoulder out here. That's what Jason Meade described. You saw the pictures of it, ladies and gentlemen. And the physical evidence matches. There is no injuries on the right hand. And both Dr. Bauer and Dr. DeMuren said, I can't tell you what's going on with the right hand. Common sense, it's your navigation. Common sense. Ladies and gentlemen, an important thing about the door is, I'll use this. Everybody said that, and you see it, that the trajectory went through the door, right? You see the bullet holes, right? And Dr. DeMuren testified to the spread. What do I mean by spread? The spread of those 3 shots, okay? Now, we know there were 6 shots. We know all 6 hit the body, okay? Now, the closer, this is the intervening object. The closer the object is to those holes, the more likely they're gonna hit. The farther the object is away, meaning Mr. Goodson, the less likely they're gonna strike the body. It's just basic thing. Put a hole through there, when you go back there, put a hole through there. All 6 hit. The farther you go away, ladies and gentlemen, the less likely that it's gonna hit the body. That's just basic common sense, ladies and gentlemen. They don't want you to use your common sense. Because it contradicts Bauer, because it puts him closer to the threshold and not farther. Ladies and gentlemen, the government's theory in this case is that somehow Jason Meade is a mentalist. He's either a mentalist because they want you to believe he didn't see the gun. Okay, I know this guy's got a gun, even though I didn't see it. So within 5 seconds, I'm gonna do a U-turn. I'm gonna do this U-turn because I know he's got a gun and I'm gonna go arrest him for it, right? No, ladies and gentlemen. He did the U-turn because he saw it. The other thing is, it's a cover-up. They put forth a theory that it's a cover-up, that Jason Meade walked out to the truck to put his lights on. Hey, here's a reason, because we asked people, do you sometimes go out and put your light on when medics are coming in? The answer was yes. That's the reason, but it's a cover-up, says Mr. Merkel. Wow, cover-up, you know what that means? That he made it up. He made everything up. Geez, I think the guy's got a gun, so I'm gonna go, and I'm gonna air it to my team. I'm gonna tell my team, who respects me and I respect them, I'm gonna tell my team and lie about what I saw, even though I describe it. Even though at the scene, a gun is found. Wow, he's the luckiest person in the world. But now I'm gonna walk around and I'm gonna make this up. Geez, I'm stuck, I got a cover up. That's what, ladies and gentlemen. He doesn't know that Sheila Stanford was interviewed. He doesn't know what Ryan Rosser's gonna say. He doesn't know that Sheila Stanford confirms all his commands. He doesn't know that Ryan Rosser confirms what he told him at the intersection of Sales and States. So you can't have a cover-up unless they're all involved. And they can't be involved because Jason Meade has no idea who Sheila Stanford is. But that's their theory. That's how desperate they are. They say Jason Meade made this up because he's a mentalist and he wanted to shoot someone in the back because he thinks he had a gun. They're doing this to someone who served their country honorably in the Marines. Someone who did 11 combat missions, not time, 11 combat missions, who's trained to do that. Someone, ladies and gentlemen, who dedicated his life to the community as a Franklin County Sheriff's deputy. Someone who then was on the SWAT team and also on the SOFAST federal team. That's somebody who lies. That's what they want you to believe. Semper Fi, ladies and gentlemen, Semper Fi. You know what it means? It's a quote for the Marines. It means always faithful.
Overruled. Closing argument.
Always faithful. Once you're a Marine, you're always a Marine. And you don't lie. They don't put you in those situations for 11 tactical combat missions if you're a liar. They don't do that. But they're saying he's lying because he has to cover up. That's their theory of the case. But we know it's not the case, ladies and gentlemen. 10 pages of words, perceptions, and thoughts and beliefs. And each and every part of that was corroborated. But one word, stopped versus slowed. The video clearly shows he didn't stop. He's mistaken about that. There's 1,993 words in there, and they've pointed out one word that he's incorrect on. Are you kidding me? Each and every part, let's go through it. His position at the intersection. He says in his statement he was in the first position. He was. And again, he doesn't know the video's there. Somehow they think the video hurts Jason Meade. Thank God the video's there because it confirms everything he wrote in his statement from memory. First there, he had an unobstructed view of right and left. The direction Mr. Goodson came, he came down this way. The traffic clearing the opposite direction, confirmed. The U-turn that was Jason's reaction to Casey Goodson's actions, confirmed. Slowing and telling Rosser. Rosser tells you this. He slowed down to tell me the guy's got a gun. You see that on the video. Pulling over at Estates. That's confirmed by Rosser. Putting his vest on, confirmed by Rosser, and you saw the pictures after the fact. Pointing out the person in the car, out of the car. Rosser doesn't see the gun. Hey, there's a guy in the car. He's out of the car. There's a guy with a gun. Rosser doesn't see it. He's not looking for it. Rosser's still trying to figure out what's going on, he tells you. The fleeing. This is the fleeing. Rosser and another described two different ways of the person fleeing. But guess what, ladies and gentlemen? You heard the sworn testimony of Sheila Stanford. She said, I know Casey Goodson, and I saw him running from somebody. It's corroborated in Jason Meade. If he's going to cover up, does he know somehow that they're all going to corroborate him? How dare they? Ladies and gentlemen, our burden, if you get there are so many building blocks of reasonable doubt, ladies and gentlemen, we don't feel you have to go to the second analysis, but in all due respect, if you do, we have proven our case more likely than not. We have proven it through Inspector Younglis, we have proven it through Dr. DeGulen, we have proven it through the sworn testimony of Sheila Stanford, and we've proven it through Jim Scanlon, as well as our cross-examinations of all the other evidence that they put forth. Disproving, adding context. Two prongs we have to prove. The first prong is whether or not Jason had a belief that he was possibly facing a serious physical injury or death from a deadly weapon, okay? 92 people testified that if a weapon's pointed at your way, it's a deadly threat and they'd be fearful, right? It's pretty simple. But they made it even simpler for us because they proved it for us. Because we talk about in voir dire, whether to put your client on or not, well, when the government puts his full 10-page statement on, you don't have to. That's their evidence. They made his testimony. They made it evidence when they had our accused read it. They put his testimony in. And one word is all they have? Jason's own words, I was in fear for my life at the time I fired the weapon. Quote, I believed he intended to shoot me and that I would be killed. Quote, at the time I fired, I did not think I had any other reasonable option to protect my life. And threat presented by the suspect's actions. Again, everything is dictated by the individual's actions. Action and reaction. Casey Goodson's gun was found underneath his torso when they turned him over. Did we prove more likely than not, because that's our burden, that he had a subjective belief? 100%, ladies and gentlemen. 100% more likely than not. Second one, how we prove the second prong. Now, again, I'm going to read it. You have it in your jury instructions. The second prong is reasonableness. Whether a reasonable officer stepping into the shoes of Jason and viewing or knowing what Jason knew at the time could believe the need to use deadly force in that situation. Not would they, but could they believe the need of that choice? And is that choice reasonable? All right? Now, how do we analyze that, the reasonableness? The Supreme Court, State v. White, gives us guidelines, and you will see them in the instructions. The first is the severity of the crime. There's three examples of the severity of the crime. The first is waving at the intersection. That's aggravated menacing. The second is when you point it at someone, that's an attempted felonious assault. Also, improper handling of a firearm, which is a felony. Attempt felonious assault is a felony. And the last one is at the door. When the guard...
Overruled this closing argument.
Felonious assault is a felony of the second degree. Attempted makes it a felony of the third degree.
Outside the evidence, Your Honor, none of this.
Overruled is closing argument. Closing argument's not evidence. You can continue, Mr. Collins.
Thank you, Your Honor. Appreciate it. So again, ladies and gentlemen, the last thing, serious crime, is when, at the doorway when he turns, when the suspect turns, when Mr. Goodson turns. Okay? Those are all severe crimes. Have we proven more likely than not that those? Yes, every single law enforcement officer told you they had a duty to, they would have a duty to investigate, and it's a serious crime. It's a threat. Depending on what you do with a gun, it's a deadly threat, a potential threat. You name it, it's serious. More likely than not. Detective Hughes even swore an affidavit to that, ladies and gentlemen. He went in front of a judge and said, I swear that these facts are true to my knowledge. And it was somebody waving a gun in a car. That's a crime. The second Graham factor you'll see in the jury instructions was a suspect trying to evade or flee. Okay, what do we know about that? Well, You have Rosser testifying what he saw. The person started to walk, then picked up. Was he eluding you? Yes. Jason Meade words, he tells you what he sees. And who else corroborates that, ladies and gentlemen? Was the suspect attempting to flee? Sheila Staniford. I see him running. He was running from somebody. So we have proven more likely than not that second Graham factor, ladies and gentlemen. That's our burden. Now, the disturbing thing about Mr. Merkel's closing is this is what he said, that we had to prove for justification that Casey pointed the gun towards him. We don't have to prove that. We have to prove his actions were reasonable, and he misstates the law. We have to prove that Jason Meade's actions were reasonable. We don't prove anything about Casey Goodson, but they can't help themselves. They have to go there. U.S. Police, drop the gun, drop the gun, drop the gun. Corroborated by 2 other people. Ladies and gentlemen, consistency and corroboration and credibility, it's not a coincidence. It's not a coincidence when it's the truth. You can't be consistent and corroborate things and be credible if it's the truth, ladies and gentlemen, and it matches the physical evidence. Those Graham factors will be there. Now, you have to step into the shoes of Jason Meade. And in this situation, ladies and gentlemen, here you have to step into the shoes of someone pointing a gun at you, leveling a gun back towards you. Those are the shoes you step into. And who did we ask if they would respond? I would submit they're all reasonable. Detective Rosser, Sergeant Stanley, Officer Rippey, Officer Penny, Marshal Youngless, Detective Williams from the FBI, Detective Kroom, Detective Hughes, FBI Agent White, even Scanlon and Stoughton both said, well, Stoughton said he hoped he would fire. Everybody else said they would fire, and everyone else would be reasonable. Those are reasonable police officers. Ladies and gentlemen, each and every action we've shown in our case of what Jason Meade's actions were based on the actions of Mr. Goodson were reasonable. Let's go through them now. Let's compare the use of force, okay? Let's go through there. Did he believe he was going to be shot and his decision to use force was reasonable? Let's go. Ms. Stevens, can I have the chart? Let's compare Stoughton, their use of force expert, with Jim Scanlon. This is a comparison I'll take every day and twice on Sunday, ladies and gentlemen. Experience. Stoughton, 5 years. Scanlon, 33. Remember when Ms. Stevens asked Stoughton, hey, would you agree that someone with 5 years of experience versus 33 is not experience? He said, yeah, I would agree with that. I don't think he knew he was talking about himself. Next one, training. Stoughton trains executives and higher ups, and oh, by the way, children in self-defense. That's what he does. Scanlon, thousands trained at all levels, ongoing, current, at every single level for 33 years, Jim Scanlon's been training, and then after that, when he had this consulting firm that went around the country to train people. Where training? None in Ohio ever for Stoughton, because he doesn't do that. Scanlon, extensive everywhere. Certified in Ohio, not Stoughton. Scanlon, yes. SWAT experience, not Stoughton. Scanlon, yes. Who do they train? This guy they put on trains first-year law students in criminal law and second-year law students in criminal procedure. And they want to compare him to Jim Scanlon? And this is the best part. He told the standards that they use. How many times did Mr. Scanlon say, I can only use the standard that's provided to me for my analysis? Their expert actually told you he was going to use a different standard than you use. Ms. Stevens.
Standard we're talking about here. I'm applying generally accepted practices, which is a different standard than, for example, what the jury is asked to provide, and a different standard.
There you go. They're expert applying a different standard. They don't even understand the standards. He told you on there, I'm using a different standard. Ladies and gentlemen, I had one job while he was testifying. I had one job. I had to count how many times Seth Stoughton on direct examination by Mr. Schroyer said the word tactic or tactical. I have a newfound love and compassion for what our court reporter does. 62 times he said the word tactic or tactical in the direct examination from Mr. Schroyer. 62 times. In your jury instructions, the word will not be in there once because you're not to consider those. But that's all they have, ladies and gentlemen. That's how they try to go to proof beyond a reasonable doubt. It's not in there, ladies and gentlemen. And then they go to the cover and the teamwork and the lights and sirens. And what did the reasonable experts say? There's a situation. The situation determines what you do. Sometimes you have the ability to take cover. Sometimes you have the ability to go slow. Other times, as Detective Hughes said, you got to be a cop. You go alone. You assume your team's following behind you. Sometimes you turn your lights and sirens on. Mr. Scanlon said in this situation, it would exaggerate the situation. Have you turned his lights and sirens on when he saw him out of the car? Because they'll flee faster. No, they want one standard, a general standard. It doesn't happen. You won't see in the jury instructions risk-benefit analysis. The higher the risk, the higher the danger. Those are Stoughton's creations. They're not going to be in there. You will see in the instructions severity of the crime, immediacy of the threat, whether Mr. Goodson was evading arrest. We have proven more likely than not those factors, ladies and gentlemen. Ladies and gentlemen, he said academia and academic like 9 times. That's because he's an academic person. He's not a trainer. He's not up on a law. And there's a saying in the practice, ladies and gentlemen, those who do. Those who do the work, do the work. Those who can't, they become law professors because they can't do the work. Timing and reaction is a big thing in this case, ladies and gentlemen. The reason that Dr. DeMullen tells you that the response time to someone perceives a threat that they fire is between 0.32 and 0.86, okay? That's the test, depending on your training and stuff like that. Now, the reason he did the timing of a 22-year-old male who turning the torso was to go into his model. Is there time between the time someone reacts, remember Jason Meade says he steps to the left, someone reacts, can you turn your torso one way or another? And the study says yes, it's 0.38, okay? So what that means is, and this is what we went over before, is I had him do it. Dr. Mullen's not saying that he was turning more to the right. He could be turning back to the left. He could be turning to the right. He could be here. But there's time from when someone sees the gun pointed at them, AKA Mr. Goodson from Jason Meade, that he could turn back this way. He could turn more that way. And it fits into the reaction time. That's what they don't understand. That's what Dr. Bauer couldn't comment because he was in the courtroom listening to what Dr. DeMullen said. Timing, Art Hughes. Art Hughes. Go ahead, Ms. Stevens. Art Hughes asked me in a clip. Or anything, right?
Yes. Can you slow down a little bit too, please?
You got it. I apologize. Yeah. Can you slow down a little bit, please? Art Hughes in a controlled setting gets to ask to slow down. You know who doesn't get to ask to slow down? Jason Meade. You know who doesn't get to hit the pause button? Jason Meade. You know who doesn't have the afforded that? Jason Meade. We did that as a group. Remember in voir dire. That fits in between 0.32 and 0.86. That's how much time you have to react. Ladies and gentlemen, I told you in voir dire, sympathy and empathy. We ask you to be superhuman. We ask you to see someone lose their life, see life-saving measures being going on, see those coroner's pictures, but yet don't let it affect you. It's an improper thing of our court system. We ask too much from you. And all I can ask you is that if you feel yourself, sympathy and empathy, if you feel yourself in the jury room, remember, go to the table with the law and the facts. Because you're going to feel that way. It's human nature. It just happens. But go to if you feel yourself saying, well, what about Casey Goodson's perspective? What about that? You got to go to the table that says you're not to include that. You're not to analyze that because that's a hard thing. But that's why he finishes with the safety. Why would someone fire a pointed gun if they had the safety on? It doesn't come into the analysis, ladies and gentlemen. I'm wrapping up, Your Honor. 5.5 years, Your Honor. 5.5 years, ladies and gentlemen, there was not one concern expressed about the Rippey video, about this, because it didn't fit their narrative. There was no report documenting the credibility of his concerns. The government believed it for 5.5 years. In the trial, the government claims Jason's words and perspective are not credible. However, 5.5 years, they believed his statement, words, and beliefs were credible. There was no memo to question it, there was no documentation, and it wasn't done in a prior under oath thing. 1,993 words that the government put in this case, in his statement, they chose to put in. It becomes his testimony. He was mistaken about one. The government wants to claim that 5.5 years of inaction. Think about this, the action of giving the statement, that's Jason Meade's action, Their reaction was nothing. Inaction for 5.5 years. Now, ladies and gentlemen, Your Honor, with the court's permission, I'd like to do a demonstration. And first, Your Honor, I'd like to ask Jason Meade to stand up, please. Come over here, Jason.
Objection, Your Honor. May we-
Overruled, closing argument.
Your Honor, may we approach?
No.
All right, I'd like the jury to observe myself and Jason Meade. Okay? Mr. Nolan, Ms. Stevens, yes. Now, this is a plastic gun, ladies and gentlemen. It's a plastic gun. It's been cleared by the deputies, okay? All right?
Your Honor, may we approach?
No.
This is what blows their entire case in Dr. Bauer, okay? And the tape measure, please. Mr. Nolan. 65.3 inches. He says 65.3 inches was the level of the barrel. All right, when that rifle was fired, 65. He said it could be 66.3, and it could be 64.3. All right, those represent those three areas. Okay, Mr. Nolder, any question on that? No. Okay. All right. 65.3. There you go. Okay. Now, here's the problem. Dr. Bowers never fired the rifle. They don't understand that. He has him, Jason Meade, standing straight up. And he has him with his feet like this, all right? Never fired. He has no idea about the recoil. He has no idea about how it kicks, how it goes higher or lower, because he's never fired it. DeMullins fired it, Scanlon's fired it, and their FBI agent fired it. And what did they talk to you about the training, the techniques of that gun? You have to put it here, ladies and gentlemen. You have to put it here because of the kickback, the recoil, they call it. You have to put it either in your pectoral muscle. Both Agent White described that as well as Jim Scanlon. You have to put it here because of the kickback. And how did Mr. Scanlon say they train people in the SWAT? They train people in this. They train with that walk, the isosceles triangle, walk and walk. What did Agent White say when you fire this? You have to lean into it, okay? Same exact thing that Mr. Scanlon did, this and this. Okay, ladies and gentlemen, this and this. Here, we're here. And remember, there's a sight on top of this, okay? So I'm gonna put this barrel, ladies and gentlemen, at 65.3 inches, all right? It'd be on top of my shoulder, ladies and gentlemen, and I'm taller than him that you just saw. And there's a sight there. There's a sight up top. I'd have to even go like this. 66.3, I'd be on my tippy toes, and I'm taller. And 64.3, there, that's level. Do the levels again. 64.3, 5.3, 6.3. Where's the butt of the gun? It's on the top of my shoulder. Mr. Scanlon said it would be impossible to fire from the top of your shoulder. Oh, you wouldn't be able to control it. That's why they put it here. And Jason had a vest on. It would be even higher. But Dr. Bauer doesn't understand that because he's never fired the weapon. That blows their entire map. Remember that floating gun that you saw? That floating gun in his pictures? He didn't put a figure there because he can't. Because it's impossible to fire that gun on the top of the shoulder, and you can discredit his entire testimony. They actually use a biomechanical expert on guns who never fired the gun. Same concept, ladies and gentlemen. That's how desperate they are. It defies common sense. The government wants you to judge this case from the screen, ladies and gentlemen. The screen. But the law requires that you judge this from the street where officers are, not what you see up on a screen. Why? On the screen, everything can be enlarged. Everything can be slowed down, made louder, replayed, enlarged, and most importantly, it can be criticized by them. On the street, Jason had to decide, ladies and gentlemen, whether the gun he had already seen twice, was going to be the gun that killed him. He had no pause button. He had no crystal ball, and he had no duty to wait for the first shot. The law does not require perfection from our law enforcement officers. It requires reasonableness, and we've proven that. Criticism of tactics that aren't in your jury instructions is not proof beyond a reasonable doubt. It's not. Even amid this tragedy, ladies and gentlemen, reasonable means lawful. Lawful means that Jason Meade is not guilty. I thank you for your time. I thank you for your effort. I thank you for your attention. And I wish you Godspeed in your deliberation. Thank you.